The E-2 visa is a great option for those planning to purchase or start a business in the United States. Here at Scott Legal, we have helped many applicants pursue E-2 visas. The E-2 visa is a temporary, non-immigrant visa, and many of our clients on E-2 visas wonder what permanent options are available to them in the form of a permanent, immigrant visa, or a green card. We have new immigration videos every week. If you are new to the channel, please hit the subscribe button and bell. You can also sign up for one of our webinars, or get a free immigration guide, by clicking the link below. While an E-2 visa does not directly or automatically lead to a green card, there are several green card categories that can be considered while on an E-2 visa. In this video, we share the most common options. At the end of this video, we also discuss some of the common flags and pitfalls associated with pursuing a green card while on an E-2 visa, so stay tuned until the end. The first green card option that many E-2 visa holders consider is the EB5 visa. To qualify for an EB5 visa, the applicant must invest at least $900,000 of their personal funds in a business, or $1.8 million if the business is not in an economically distressed area. The E-2 visa holder might satisfy this requirement by investing the required amount in their E-2 business. The EB5 applicant must also hire 10 full-time employees over a 2-year period. Employees hired by the E-2 business could count towards this number, assuming that the E-2 investment was made prior to hiring, and in order to support those employees. Unfortunately, if the E-2 visa was based on a business purchase, the investment amount cannot be counted towards the EB5 investment. Alternatively, an E-2 investor with available funds could satisfy the EB5 requirements by investing in an EB5 Regional Center. This is a much more passive form of investment and would allow the individual to continue to operate the E-2 business while waiting for their green card. Another green card option for many E-2 visa holders is the EB2 National Interest Waiver, or NIW. This option is available to entrepreneurs if they can show that the benefit they bring to the U.S. outweighs the normal requirement for labor condition certification. To be eligible for an EB2 NIW visa, the applicant must hold an advanced degree or the equivalent, or have exceptional ability. The advanced degree can be a master's degree, or it can be a bachelor's degree with 5 years of progressive experience. Exceptional ability means a degree of expertise significantly above that ordinarily encountered in the sciences, arts, or business. Note that the applicant does not necessarily need a degree if they can satisfy the exceptional ability standard. To qualify for an EB2 NIW visa, the applicant must show several things. First, the applicant must show that the business has both substantial merit and national importance. Endeavors that are local or regional can still be considered of national importance. Second, the applicant must show that she is well positioned to advance the endeavor. This means that she must have the relevant education and experience to move the endeavor forward. Finally, the applicant must show that, on balance, it would be beneficial for the government to waive the labor condition requirement. Since entrepreneurs who own a majority of a company are not eligible for labor certification, this category may have already been satisfied, or might not be relevant to a particular applicant. Some E-2 visa holders may be able to qualify for a green card in the EB1 Extraordinary Ability category. To qualify, the applicant must meet at least 3 of the 8 extraordinary ability criteria, which are designed to show that the applicant has risen to the very top of their profession. While this is a high standard to meet, a qualified lawyer can help an applicant review any awards, publications, media appearances, leadership roles in organizations, or other pieces of evidence that can be used to show that they satisfy the extraordinary ability standard and qualify for an EB1 visa. Finally, if the E-2 visa holder is in a relationship with a U.S. citizen or lawful permanent resident, marriage to a U.S. citizen or green card holder are relatively fast paths to a green card. There are other family-based green card categories available to individuals who are related to U.S. citizens or lawful permanent residents, though these could involve a longer wait. There are a number of critical considerations that must be remembered by E-2 visa holders thinking about pursuing a green card. First, an E-2 visa is not a dual intent visa, which means that it should only be given to individuals who intend to depart from the U.S. at the termination of the visa. As a result, renewing the E-2 visa or even entering the U.S. could be problematic for those who have a pending green card petition. Timing is very important for E-2 visa holders who are applying for a green card. Second, the E-2 company cannot sponsor for a green card the E-2 visa holder who owns and controls it. This means that the EB2 and EB3 visas are not available for E2 investors to work at the same E2 company. However, an E2 investor can be sponsored by a different company under the EB2 or EB3 categories. Third, remember that once the E2 investor receives a green card, the E2 company could no longer qualify as an E2 company. As a result, any employees of the business who are on E2 visas may be ineligible for E2 status once the E2 investor receives a green card. Finally, note that, if a green card petition is denied, the denial could impact future attempts to renew the E2 visa. If you are thinking about navigating the path from an E2 visa to a green card, Scott Legal is here to help. You can contact us by calling 212-223-2964, or by sending us an email. You can also schedule your consultation by clicking on the link below, where you can choose a day and time that is most convenient for you. We look forward to hearing from you.